Good morning, one and all. The Director of the Judicial Academy, Mr. Sharma, the Deputy Director, Ms. Bhutia, my worthy colleagues, Mr. Benoy, Sharma, CPC, and Ms. Ranjeeta, Pradhan, District Judge, Pakyong, the Additional Secretary, Additional Registrar, the Joint Registrars and the Deputy Registrars from the High Court, the Peshkars and all the officers and members of the staff from the District Judiciary. Good morning to one and all, and I would like to welcome all of you from the other districts to Gangtok. Today, we are in a sort of a cusp. I think that will be in the history of the criminal law of our country, where the 3 new criminal laws have already come into force on the 1st of July 2024. And I am told that the cases have already started. It is already registered and the investigation of the cases have already begun under the new provisions of law. Therefore, it is very, very important for all of us in the courts, as one of the wing of the criminal justice administration, to understand the nitty-gritties of these new criminal laws. Most of you are experienced in dealing with cases when it comes to the court, presenting it before the presiding officer, and also dealing with the advocates as well as the litigants and the accused persons. Amongst the 3 criminal laws that has already come into force, I have been given the portion concerning the Evidence Act, or the Saksha Adhiniyam, Bharatiya Saksha Adhiniyam, or the Indian Evidence Act, which was in place and still is in place for the old cases until we dispose it off. Therefore, you may first, it's not that you do not know what is an evidence, but I will give you with an illustration. Let's say, for example, there is a commission of a murder. Somebody is murdered on the street. A is the eyewitness. A saw B murdering the victim, let's say C, on the street. There were some bypassers on the road, D and E, who was walking by, and as they were walking by, A, who is the eyewitness, comes and shouts that there is a murder. Mario, Mario. I know? In a local language, I'm telling you, Mario, Mario. So what happens is that D and E has not actually seen B stabbing or murdering the victim, but has heard A shouting, Mario, Mario. यसो हेर्दाखेरि त्यहाँ एकजना मान्छे लडिरहेको रहेछ in a pool of blood. So what is this? This is a circumstance concerning a scene of murder. So how do we bring this and prove it in the court of law, after the investigation of the case is over, is dealt with what we call the Evidence Act or the Bharatiya Sakshya Adhiniyam. If you see the provisions of this particular act, you will find that the entire act will be mostly divided into three aspects of the relevancy of facts, how these facts are to be proved, and the mode of proving these facts. So, what is it that D and E have heard A shouting, Mario, Mario, Ranjeeta? Right? So, will that be a relevant piece of evidence? Will be a question in the court. So, if we see the Evidence Act, these type of evidence is normally known as some facts which are relevant and which are known as res gestae. Right? It's a Latin term. Res gestae भन्ने मतलब के हो भन्दाखेरि things which have become or which has happened spontaneously. है कसैले सोचेको होइन, कसैले पछि सम्झेर भनेको होइन, तर जुन चाहिँ इमिडिएट रियाक्सन हुन्छ मान्छेको, त्यसलाई हामीले रेस जेस्टे भनिन्छ. र दिस टर्म कल मारियो मारियो भनेर जुन चाहिँ एले कराएको छ, these facts will be relevant in the court by virtue of the relevancy of facts known as res gestae. So these are certain things which we are to understand as the officers and members of the staff of the criminal justice system, not only criminal justice system, but also the civil courts so far as the Evidence Act is concerned. Now my brother and sister here will be dealing exclusively on criminal law, on the penal provision and the code of criminal procedure. And what I will be dealing is on the mode of proving it, the evidence. And the mode of proving it is not only for criminal cases, but equally applies to civil matters. So if you divide laws, it can be divided into two aspects: substantive law and procedural law. So what is substantive law? The question may come up in your mind, what is substantive law? Substantive law भने यो कानुन हो, that law which defines your rights, your duties and your liabilities. उदाहरणको लागि, the Indian Penal Code or the BNS now, what does it do? It defines what is an offense and also prescribes punishment. So these are substantive law. Otherwise, there are many members of the staff dealing with NDPS matters, SADA Act, POCSO Act. So what are these acts? These are substantive law. र यो लजहरूले के गर्छ? It defines what is an offense, the categories of offense, and the punishment prescribed for these offenses. These laws are known as substantive laws. Now, how do we collect evidence? How is investigation to be done? How is an FIR to be registered? What are the means that an investigating officer adopts while conducting investigation is what is known as procedural law. What we call as the code of criminal procedure, जुन चाहिँ 1973 को कोड छ अहिलेसम्म थियो. It defines the procedure of investigation of how these substantive law is applied. Now procedure can also be divided into two. One is the means of conducting this kind of investigation, such as what the code of criminal procedure prescribes, and the means of proving these facts. र जब proof को कुरा आइन्छ, then the Evidence Act comes into play. So what does the Evidence Act does is it is a procedural law which is a means of proving these facts which are in issue. You got my point? All right. I will not try to teach you Evidence Act because I am sure most of you must have already you're already well versed with these Evidence Act, and in the last two sessions that I have taken on Evidence Act, I have tried to give an understanding of what is an Evidence Act, and though there are not much changes in the present Adhiniyam of 2023, but I have tried to go into details of what is an Evidence Act, the sections that are involved, so on and so forth. But I realized that it took a little long time. So therefore what I'll try to do is stick to my time and tell you about the new act, or the Bharatiya Saksha Adhiniyam of 2023. हजुरहरूलाई थाहा भएको कुरा होला, this act, particular act, this was presented first in the Lok Sabha on the 11th of August 2023. त्यसको बाद हाउसमै त्यो बस्यो, कतिवटा चर्चाहरू भयो, र on the 12th of December it was withdrawn, and instead the second bill was introduced, and on the 20th and 21st of December 2023 both the houses, Lok Sabha as well as Rajya Sabha, passed the bill, all the three bills, and then it went to the President for the presidential assent. र जब प्रेसिडेन्टले उहाँको सिल लगाएर उहाँको एसेन्ट दिनुभयो 25 December 2023, then these act came to be known as the law. The bill then became law. What happened then was that there was discussion all over the country. There was a lot of resentment from lawmakers, from lawyers, from investigating agencies about this new laws and the efficacy of new laws and the necessity of bringing about a change. There still is a lot of discussion going on as to what is the need of bringing these laws, which I don't intend to get into in this particular session. But then the Government of India, the Home Ministry, notified that from the 1st of July 2024, these three new acts will come into effect. र हालैमा हामी यही महिनाको जुलाईको महिनामा छौँ, आज 6 तारिक हो, र 1 तारिकदेखि these laws have become applicable. Therefore, all of us must understand and must be well versed with these laws so as to help us in our day-to-day work, and also help the court, the presiding officer, as well as the lawyers while dealing with any type of cases that comes under or falls under these three categories. Now another thing what I'd like to tell you all is a certain basic principle of the Evidence Act. Hazurहरूले, when you all try to understand the Evidence Act, there are certain cardinal principles. You say, के भन्छ भन्दाखेरि यो मूल मन्त्र भनेको जस्तो नि. These are certain cardinal principles of the Evidence Act that one should always keep in mind while trying to interpret and while trying to understand the Evidence Act. Number one, hearsay evidence is not admissible. कसैले भनेको सुनेको evidence is not admissible. Number one. Number two, in all cases, the best evidence must be given. These are certain things that I thought all of you should keep in your mind while trying to understand and while trying to read the Evidence Act. And what does the Evidence Act actually do is it prescribes the mode of proof, and also it regulates what evidence are admissible, what evidence are not, in order to save the time of the court or the judge in admitting the evidence and bringing about a logical conclusion to a trial. The lawyers from both the sides will try to bring in every and all type of evidence, whether there is relevancy, whether it is not, whether it is required, whether it is admissible or not. These facts will come into court. It will come into your doc, it will come into the case record, which will complicate things, and ultimately it may also lead to travesty of justice. So in order to prevent all this, there is a law to streamline what kind of evidence you are to admit, what kind of evidence you are to reject, and how are these evidence required to be proved in the court. So please keep these things in mind. Now I come to the BSA, or the Bharatiya Saksha Adhiniyam of 2023. Now these are the highlights that I'd like to tell you. There are not much changes in the Evidence Act, but you will see that in the definition of the word evidence, apart from others, they have also included, there is an inclusion of the electronic evidence. र हजुरहरूले नयाँ Evidence Act पढ्नुभयो भने there is quite a heavy reliance, or there is quite a heavy inclusion of electronic evidence. अनि BSA ले के गरेको छ भन्दाखेरि it has tried to integrate the definition in BSA along with the new Criminal Procedure Act code, the new Indian Penal Code, and also the IT Act. So the object that comes to my mind is perhaps the object of the legislature is to streamline, make it easy and more understandable so far as the evidence is concerned, and that there is a connection between these acts or these laws. All right? Now the other highlight is that the electronic as well as the digital records has been made admissible. The secondary evidence also includes oral account of a person who has seen the document, and it seeks to limit the facts which are admissible and its certification. तपाईले हेर्यो भने कतिवटा चेन्जेस देख्न सक्नुहुन्छ कि certain words and phrases which are which are the old phrases, no more relevant in the present context. These have been deleted. Heर्नुहोस्, United Kingdom, London Gazette, these are all old laws. होइन त? Because the Indian Evidence Act is a very old act of 1872. So many of these changes have been brought about. Words like vakil, pleader, barrister, attorney, these have also been replaced with advocate. Does it come to your mind? किन भनेर यो ब्यारिस्टर, प्लिडर, वकिल, अटर्नी हामीलाई त एउटै सुन्छ हैन त? What is the difference between all these? तपाईहरुको मनमा आउँछ यस्तो कुराहरु? What is the difference between a barrister and an advocate? किन एडभोकेट लाउनु र ब्यारिस्टर निकाल्दिनु? आउँछन् यस्तो प्रश्नहरु? Does it come to your mind? I'm sure it comes to your mind. Would anybody like to attempt what is the difference between all these? Maybe it is not relevant. I'm just trying to bring about some sort of a dialogue. Otherwise, it becomes a monologue. होइन त? र दुईपट्टिबाट नै केही भन्नु छ भने अब हेर्नुहोस् यो ब्यारिस्टरहरू भने these are the old, I don't say it's old, but so far as our context is concerned, during the time of the Britishers, many people from our country went to England, studied law there, passed their law examinations there, and then what they became is known in Britain as the barrister. So a barrister is also an advocate, but who has passed the law of England. होइन त? र पहिला यो, as I said, please keep that in your mind. 1872 को Indian Evidence Act was long time ago. That was pre-independence legislation. होइन त? तपाईहरुले, if you see the Evidence Act, it goes much behind even 1872. If you see the history of the Evidence Act, it goes much behind. पहिला के थियो त? इन्डियामा there was no uniform set of rules governing evidence. होइन? As I told you, procedure, criminal procedure code फाल्टै हुन्छ, mode of proving in the court फाल्टै हुन्छ. So the way of proving these facts in the courts, there was no uniformity at all in India. र त्यति बेला के हुन्थ्यो भन्दाखेरि there were presidency towns. तपाईलाई थाहा छ हैन? Yeah, there are, Mr. Manna is from Calcutta. होइन त? There were presidency towns, Calcutta being one of them. So in these presidency towns, there were presidency courts. Calcutta, Madras, Bombay. And your presidency towns, there was some uniformity, there were some laws which was prevalent there to govern the Evidence Act. But the majority of the other states, princely states, including if you see the history of Sikkim as well, we did not have a set of rules or a set of scientific principles to admit evidence and to prove it in the court of law. हाम्रै सन्दर्भमा तपाईहरुले बुझ्नुहोस् न त, सिक्किममा के हुन्थ्यो? A thief had to prove his innocence by, सुन्नु भएको हैन तपाईहरुले? उम्लेको तेलमा हात हाले पनि अगर उलाई जलेन भने he is innocent, जल्यो भने यो मान्छे guilty. सुन्नु भएको यो कुराहरु? यस्तो कतिवटा पहिलाको लजहरु सुन्नु भएको? These have no scientific basis. होइन त? र it was not only followed in Sikkim. If you see the other princely states around the country, and perhaps even in other countries, there were these sets of rules governing evidence. र बिस्तारै बिस्तारै के गर्यो भन्दाखेरि later on, the then East India Company, or the Britishers then, they brought in a set of rules and regulations from their own Evidence Act. ब्रिटेनमा अलरेडी थियो र उहाँले त्यहाँबाट कतिवटा ल्याएर यहाँ एउटा लेजिस्लेसनको रूपमा they presented it, thinking that there would be some uniformity, some codification of the Evidence Act. But the moment they brought it in our native land, जब princely states-हरुलाई discussions-को लागि दियो, it was rejected outright. हुँदैन हाम्रो यहाँ. In a country like India, यो कुराहरु हुनु सक्दैन भन्यो. But things it went on like that. And finally, this 1872 Act, which has been properly codified, a lot of things has been brought about, amendment, and then it was brought as the Indian Evidence Act of 1872. But I may say, with all conviction, that over these years, I have found that the Indian Evidence Act of 1872 is one of the best piece of legislation. One of the best laws of a country is the Indian Evidence Act. तपाईहरुले पढ्नुस् न त. It had how many? 168 sections होला पहिलाको. हैन अहिलेकोमा 170 छ. But these 168 to 169 sections of the Indian Evidence Act is full of wisdom and is full of logic. And therefore, this particular act has now come and it has been replicated as the Bharatiya Sakshya Adhiniyam with certain changes, as I told you, mostly about the electronic evidence, because the Indian Evidence Act being pre-independence legislation or the law, there were many amendments brought into the Indian Evidence Act so as to bring it in the mainstream. अहिले के छ त? अहिले सबैको गोजीमा स्मार्टफोन छ, सबैको घरमा टिभी छ, स्मार्ट टिभी, प्रायको घरमा ट्याब्लेट्सहरु छ, आइप्याडहरु छ, हैन त? र प्रायको घरमा कम्प्युटर्स छ. र most of our activities are confined to these electronic gadgets. भनिन्छ नि कि if you want to know a history of a person now, it's just get his mobile phone भन्छ नि. कसैको मोबाइल फोन लिएर हेर न त. Check the mobile phone and you will know what kind of person that person is. भन्नु मतलब हाम्रो यो गोजीमै मोबाइल फोनमै सबै कुराहरु छ. Right from our personal accounts, तपाईहरुको बैंक कहाँ छ त? Do we normally go to banks like we used to do earlier? कतिजनाको लोनहरु छन्, जानुहुन्छ होला. तर अहिले के छ त भन्नुस् त? Is there anybody who has gone to the bank over the last 1 year? 1 month? हामी जान्दैनौँ नि त, किनभने बैंक इज इन योर पकेट. SBI को योनो छ, हैन त? सेन्ट्रल बैंकको पनि एपहरु छ. थुप्रै यस्तो एपहरु छ र भन्नु मतलब these things were necessitated and therefore it has been brought into as the evidence, electronic and digital evidence. So if you see the Evidence Act, the old Evidence Act, the Evidence Act was not applicable to these court-martial, Army Act, Navy Act, Air Force Act. This was not applicable at all. But now, the BNS, Bharatiya Sakshya Adhiniyam, is also applicable to the court-martial. So these are certain changes that has been brought about. In the definition of documents, digital records and electronic records has been added. In section 4, the principle of res geste, which I just told you, is made applicable to fact in issue as well as the relevant fact. Section 24, 23, 24, 25, these are very important sections of the Evidence Act. पहिला के हुन्थ्यो भन्दाखेरि a confession made before a police officer is not relevant until certain things are kept in place. Statement made before a magistrate, there was relevancy not only under 24, 25, 26, but also under 164 of the Indian Evidence Act. And what they have done is they have clubbed many of these sections together and brought it as one, which I will come a little later. Katijana accused, when there is a co-accused, and if there are some accused who are proclaimed offender, उहाँहरूको जब एभिडेन्स हामी रेकर्ड गर्छौँ proclaimed offender को, त्यति बेला if there is an evidence of a co-accused, that also becomes relevant against the proclaimed offender, so far as this new act is concerned. Digital records मा बुक्सहरू, law बुक्सहरूको पनि relevancy उहाँले admissible बनाएको छ र in primary evidence section 53 these provisions have been included. Digital electronic record, multiple files हरूमा नि जस्तो multiple files भन्नु के बुझिन्छ भन्दाखेरि in these context certain videos, certain messages that comes to your phone through WhatsApp, through let's say SMS, whatever it is, through any other app, you forward it to your friend through through WhatsApp, या Facebook तपाईहरुको पोस्टहरु छ र सबै यो कुराहरु if you start forwarding it, somebody keeps it in the phone, somebody again saves that video in his laptop or a tablet, somebody may save it in their pen drive, हैन त? Yeah, in a court like ours, we also have servers. It may go to server, it may be saved there. So what happens is these multiple files, तपाईको फोनको, फल्नाको फोनको, फल्नाको पेन ड्राइभको, फल्नाको हार्ड डिस्कको, whatever multiple copies have been made, now these are all primary evidence. Now the mode of primary evidence, how to prove it is a different aspect, but it has also been included in the primary evidence. Video recording, these have all come as primary evidence. Now in secondary evidence, oral admissions made, the written admissions made, or the evidence by a skilled person, these have also been included as secondary evidence. Now the way of proving secondary evidence is also different, but these factors have also come in BNS as secondary evidence, which was not there in the Indian Evidence Act. All right. Now section 63, electronic records, which are copied in flash drive, server, cloud, whatever you keep it, and that also becomes your primary evidence. The other aspect that one has to keep in mind is that 65 ABC or 65B ma ke थियो भन्दाखेरि it was sufficient if a person who is in charge of that computer or that machine to give a certificate signed by him saying that this particular document or this particular evidence was in my custody, and in a normal course of event I was in custody of this computer. That was sufficient as the certificate required under 65B, but now this new provision of 63 has, if you see a schedule which is appended at the end of the act, यहाँ format दिएको छ 65B को सर्टिफिकेट कस्तो हुनुपर्छ भनेर नि 65B भन्नु मतलब पहिलाको 65B तर अहिले 63 हुन्छ, but if you relate it, it is correlate, you can correlate it. Along with that particular signature of a person who was in possession, there has to be a counter signature of an expert पनि भनेको छ, right? So these are certain requirements that one has to keep in mind while bringing in about the new certificate required under 63. Now this is about Stoppel. This is also a new provision which has been added about between the landlord and tenant. कोही बेला अब यो Tenancy Act मा नि when there is an eviction suit, जब tenant कसैकोमा rent बसेको हुन्छ, at a later date the tenant will be stopped. उहाँले भन्नु पाउँदैन, उहाँको मुख बन्द बनाउँछ कि फलानाको टाइटलै थिएन भनेर नि. At this point of time, what happens is there are a lot of cases in the court under the Evidence Act जहाँ चाहिँ टेनेन्टले पछि आएर के भन्छ कतिवटा केसेसमा, यो ल्यान्डलर्डको त टाइटलै थिएन यो जमिनमा या यो बिल्डिङमा भनेर there are these kind of defenses also taken, which has been done away with by the inclusion of this new provision under 122 of the BSA. The word lunacy has been replaced with mental illness. These are certain small things which has come about, and this is one new provision which is also known as privileged communication. A communication between the ministers and the President of India cannot be admitted as evidence भनेर आएको छ. र what is the logic behind this? I do not know, but this is a provision which has come. I'll just give you in brief the comparative chart. ल अहिलेको तपाईहरुको भारतीय साक्ष्य अधिनियम vis-a-vis, if you compare it with the Indian Evidence Act, what are the changes? You will notice that there are not much changes in the present Evidence Act. The superstructure or the edifice, यो जुन चाहिँ skeleton छ, it is the same. यसमा अलिअलि यताउति थपिएको छ र सेक्सन्सहरुलाई यताउति र माथि मुनि लगाएको छ. But I am sure that you should understand that there are these kind of changes which will help you in dealing with the cases when it comes to the court. Section 1 मा के बनाएको छ? The proceedings before the court martial. It has been included. Repealed जुन चाहिँ छ त्यो it has been deleted. Definition clause मा, definition clause if you see, which was section 2 earlier in the Evidence Act, there is a lot of changes from here to there, here to there. And there are not much new things except for electronic evidence, but certain things which are the basic principle, may presume, shall presume, these definitions have been put into definition clause by bringing it from here to there. Section 5, there is no changes. Section 6 of the Evidence Act 1872, there is a minor change. There is a minor change in section 9. यहाँ कतिजना पेशकरहरू हुनुहुन्छ नि त हैन, from the magistrate courts. Section 9 को एप्लिकेशन्सहरु आइन्छ तपाईहरुकोमा? को हुनुहुन्छ यहाँ म्याजिस्ट्रेट कोर्टबाट? हैन? एक दुई जना छ? एक दुई जना मात्रै? सेक्सन 9 के हो त भन्दाखेरि तपाईहरुको टेस्ट आइडेन्टिफिकेसन परेडहरु जब गरिनुहुन्छ, that was being done under the provision of section 9 of the Indian Evidence Act, which is now Section 7. Right? There are these things which has to be done. Which I don't intend to repeat. There are no changes here at all, except the sections have been brought from one to another. No changes. (23) As I said, the words barrister, vakil, so and so, deleted. Section 24. Keep on answer. Section 24. 28 and 29 has been clubbed together to be brought as Section 24. Section 25 and 26, these three provisions, 24, 25 and 26, this has been clubbed together. होइन? र जब मैले अस्ति पुलिस अफिसर्सहरूको लागि र जजेसहरूको लागि पनि इन्डियन एभिडेन्स एक्ट या त BSA हामी जब डिस्कस गऱ्यौँ, I paid a lot of attention to these particular provisions, which are very important for the courts. So far as admissibility is concerned, I will not take much time with you all, but one should understand that a confession made before a police officer will not be admissible in law. र हाम्रोमा आइ नै रहेको सधैँ आइरहेको प्रोभिजन के हुन्छ भन्दाखेरि section thereafter 27 थियो नि त. 27 is also clubbed together. 27 मा के छ? Disclosure, and you find that particular piece of evidence based on the disclosure statement of an accused. होइन? So 27 was very important for the courts, and it has been clubbed together and it has been brought in as the Section 23. Is there any question on Section 27? Dhara 27, Section 27 मा जब तपाईहरुकोमा disclosure statement मा recovery हुन्छ, does it strike to you or does it come to your mind that there are these questions? हामीले यो provision अलिकति बुझेको छैन भनेर कसैको केही प्रश्न छ? Because if you want, you can ask me, right? Otherwise, I am going to go ahead, because 27, so far as the court is concerned, it becomes very relevant. होइन? स्टाफहरु पेशकर्सहरुको काम के हुन्छ भन्दाखेरि you just present it. Oh, but you have noticed that there is a lot of discussion during argument. There is a lot of questioning to the IO and to these two witnesses whenever there is Section 27 statement is produced. Admissibility को टाइममा कतिवटा उहाँहरूले अब्जेक्सन्सहरु लगाउँछ सुन्नु भएको हैन तपाईहरुले? यसमा तपाईहरुको केही प्रश्नहरु छ? केही छ भने सोध्नुहोस् है। र सोध्नु छैन भने तपाईहरुले खाली यति मात्रै याद राख्नुहोस्, सेक्सन 27 मा एडमिसिबल गर्नु नगर्नु त्यो प्रिसाइडिङ अफिसरको उहाँको पावरमा हो। तर हामीले एज अ जनरल पर्सन अल्सो वी शुड अन्डरस्ट्यान्ड that the Section 27 statement will be admissible. Section 27 पहिलाको है, it will be admissible only that portion where there is recovery made. For example, तपाईहरुलाई भन्नु भने नि मैले बीलाई चुप्पी हिर्काए, चुप्पी हिर्काउँदाखेरि ऊ मर्यो, त्यहाँबाट भागेर मैले त्यो चुप्पी जुन चाहिँ छ छानाको त्यहाँ माथि घरको उता लुकाएको छु भन्छ नि। पुलिसले के गर्छ? यो स्टेटमेन्ट रेकर्ड गर्छ नि, दुईजना विटनेसेसहरु राख्छ। अहिले त अझै भिडियोग्राफी छ, कतिवटा डिजिटल एभिडेन्सहरु उहाँले लगाइदिनु भएको छ हैन त? र when it comes to the court, हाम्रोमा त त्यो डल्लै स्टेटमेन्ट आउँछ नि। 27 becomes relevant. कहिले relevant हुन्छ? जब based on that statement, if there is recovery of that particular article, त्यो जुन चाहिँ चक्कु छ, जुन चाहिँ चुप्पी छ, त्यो रेकभर भयो भने that statement will be relevant. Kina? Because there is some truth in the statement made before the police officer by the accused. Those 27 is an exception to the rule that a confession made before a police officer is not admissible. You see, the exception. Kina? Because there is some truth. Recovery भयो नि त उले भनेको जस्तै चुप्पी भेटायो. But that particular phrase, मैले उलाई चुप्पी हिर्काएर ऊ मर्यो भने जुन चाहिँ छ त्यसलाई एक्सक्लुड गर्नु पर्यो. र मैले चुप्पी लुकाएको छु जुन चाहिँ म देखाउन सक्छु, if there is recovery, that statement will be relevant. As I said, these things are the prerogative of the court, but as a general person also, we should understand that these are the basic principles of the Section 27 of the Evidence Act. Pullu kori kotia, you can note it down, right? Pullu kori kotia. This is a famous landmark judgment. Privy Council ko judgment, sir. You can take a note of this particular judgment. You see it. तपाईहरुले गुगलमा सर्च गरे भने पाउनुहुन्छ. पुल्लु कोरी कोटिया is Privy Council ko time ko and is still regarded as the leading case so far as the recovery and disclosure is concerned under 27 of the Indian Evidence Act. But these are some landmark judgments. यसमा पनि ज्यादा चेन्जेसहरु छैन. Section 39 पहिलाको 41 मा not much changes except के हुन्छ त भन्दाखेरि Section 41 of the old act, if there is a judgment of a particular court which comes to you, that becomes relevant. त्यसमा कसैको केही भन्नु हुँदैन. तर पहिलाको एक्टमा के थिएन भन्दाखेरि the order or the judgment passed by tribunal. र अहिलेको कोडमा के गर्यो भन्दाखेरि अहिले the judgment of the tribunal also becomes relevant by virtue of this provision of 41. Tribunal भने के tribunal त हैन? हाम्रोमा त मोटर एक्सिडेन्ट क्लेम ट्राइब्युनल छ. तपाईहरुले अरु जग्गा हेरे पनि थुप्रै ट्राइब्युनलहरु छ नि त. क्लेम्स ट्राइब्युनलहरु हुन्छ कतिवटा. Let's say for the government employees there are certain other tribunals. So the judgments of all these tribunals have also become relevant by virtue of its inclusion in Section 41. Section 42, 43, 44. There are no changes at all. 45 के हो त भन्दाखेरि एक्सपर्ट एभिडेन्स. हामीले एक्सपर्टहरु एक्जामिन गरेको हुन्छ कोर्टमा र त्यसमा 45A पनि लगाइदिएको छ जहाँ चाहिँ the experts in the field of foreign law, science and art, they have also been included as experts. Their evidence has been included as the expert evidence. 46, 47, 48, 49, no changes. 58 till 58, no changes. 57, judicial notice, there is an addition. Laws having extraterritorial jurisdiction. International treaty where India is a participating or the signatory country. These have been made things which are to be judicially noticed. Now these certain things which are not relevant, these have been deleted. Till 61, there are no changes. In primary evidence, as I told you, the digital evidence or the electronic evidence, this has been included. And also in secondary evidence, oral admission, written admission, etc. has been included. Section 61, digital or electronic record. This is a new provision which has come. 62 has become 65A, no change. 65B मा अघि मैले भनेको जस्तो कतिवटा यहाँ चेन्जेसहरु गरेको छ. What is important is to see the schedule to that particular act. So this is the schedule. A certificate has to be submitted along with electronic evidence at every instance. Right? A single certificate was sufficient, but now there also has to be a certificate, another certificate, as per the schedule, duly signed by expert. And so far as dealing with electronic evidence, the definition under the IT Act is also merged, and you can also relate to various definitions under the IT Act of 2000. So under 66, 67, 68, there are not much changes at all. 79, so and so, there are not much changes. I'd like to request you all, please tell me and stop me wherever you want an explanation. Right? किनभने कतिवटा चेन्जेसहरू छैन भने तपाईले गरिरहेको कुराहरू म दोहोऱ्याउनु छैन र कहाँ तपाईहरुलाई ठीक लाग्छ मलाई रोकाइदिनुहोस् है. So there are not much changes here except for some deletion. Presumptionsहरुमा बेसी छैन. यसमा कतिवटा चेन्जेसहरू, the one which is in blue color, these are the changes brought about by the new act. Presumption 65, 85A लाई 85 बनाएको छ, where digital signature has been included as along with electronic signature. Presumption 90 मा there are these little changes that has been brought about. 91A को जुन चाहिँ electronic records मा presumption छ, more than 5 years old, this has been included there. Please keep in mind, I think these are certain changes that has been brought about, keeping in mind the technology or the age that we are in right now. No changes at all. No changes at all. No changes except 113 has been deleted. No changes at all except for one or two words here and there. Words like lunatic has been replaced with mental illness. So these are only certain changes. Barristers, these words have been replaced. No changes except for certain words. No changes at all. There is no change at all here. 2, 54, 55, 57 to 60. No changes. Therefore, I do not feel it necessary to repeat it. These are certain things which are changed. Must, it has been replaced by the word shall. So we come to the end. As of now, we have 170 sections, and the last section is the repealing section. Now what you have to remember is all the offences where investigation has already begun, where the trial is in the court, the old acts will be applicable, and the new Evidence Act, also the Criminal Procedure Code or the Penal Code, will be applicable only to those cases which has been registered on or after 1st of July 2024. So for these old cases, the Indian Evidence Act of 1872 will be applicable. That is under 170 if you see this. That is all. If you have any questions, please let me know. Otherwise, I think I'm done with my presentation. Any questions from any quarter? As I said, I think for the officers and staff, the procedure will be more important because there are quite a number of changes in the Criminal Procedure Code, and also the IPC will be relevant. But Indian Evidence Act, you have seen it, there are not much changes. I've just tried to tell you some basic underlying principles of the Indian Evidence Act of 1872, which is also brought about in the BNS of 2023. हजुरहरुको केही प्रश्नहरु छ भने गरिदिनुहोस्. So I think I've stuck to my time, and if there are no questions, further questions, thank you, sir.
It's still good morning. 125 and Learned Director, Principal District and Session Judge, Madam Ranjeeta, Pradhan, and all the officers of the High Court and District Courts. मेरो टपिक चाहिँ पहिलाको CRPC जुन थियो, अब CRPC भनिँदैन, BNSS भनिन्छ। यसमा छ अनि यो जुन चाहिँ नयाँ लज आएको छ यसको बोथ साइड्स छ। One is a good side, the other side is the critical one, which सबै कुराको दुईटा फेस त हुन्छ। एउटा कोइनको दुईटा साइड भने जस्तो यसको पनि राम्रो पनि भनिन्छ, कतिवटा जुन आएको छ त्यसलाई यो ठीक भएन भन्ने एउटा सर्टन सेक्सन अफ लीगल luminaries or statesmen are also there. We begin with what has been included in the new BNSS, that is भारतीय नागरिक सुरक्षा संहिता। पहिला त्यो संहिता भनेको इट्स अ कोड है। सुरक्षा is a protection word which I am still trying to find why they called it protection. अब इङ्ग्लिसमा भन्नु भने Indian Citizen Protection Code, right? अब यो जस्टिस जुन चाहिँ है हामीले सुन्दै आएको, तपाईहरु सबैजना कोर्टमै काम गर्नुभएको, सबसे इम्पोर्टेन्ट चिज कोर्टमा, चाहे हाई कोर्टमा होस्, चाहे सुप्रिम कोर्टमा होस्, चाहे डिस्ट्रिक्ट कोर्टमा हो, इज टाइमली कन्क्लुजन अफ केसेस, विच इज क्वाइट डिफिकल्ट इन्डियन सिनारियोमा। बट स्टिल सिक्किममा यो तपाईहरु देख्नु भएको छ, हाम्रो कोर्टमा केसेसहरु धेरै छिटो सकिन्छ। तपाईको मोर देन 10 इयर्स केस त एकदमै कम्ती छ हाम्रो, 5 to 10 इयर्स सर्टन केसेस छ। मोस्ट अफ द केसेस चाहिँ 0 to 3 इयर्स बिचको छ। तो 3 वर्ष पनि एउटा केसको लागि एकदमै लामो समय हो, जो त्यसको स्टेक होल्डर हुन्छ, स्पेशली द पार्टिज जसको केस चल्दै गरेको हुन्छ। हामीले त कोर्टमा देख्छौँ है, डेट लाउँदा डिसेम्बर आएको याद हुँदैन, तर एउटा पार्टीको लागि त्यो डिसेम्बर निकै लामो हुन्छ, हाम्रो लागि छोटो भए पनि। हामीले त कहाँनिर केस हाल्नु, यसलाई चाहिँ कुन खाली डेटमा हाल्नु भन्दा 1.5 महिना 2 महिना उता पनि जान्छ। बट फर अ पर्सन हु इज कमिङ टु अ कोर्ट टुडे, आजको दिनमा आएर 1.5 महिना बादमा डेट लाग्दैछ भने इट्स रियली डिसहार्टनिङ। हामी पनि त्यो जग्गामा हो भने इट्स डिसहार्टनिङ। मान्छे बिमार भइरहेको छ, हामी डक्टरकोमा जाँदा 1 महिना बाद आइज भन्यो भने आइदर वी विल कर्स द्याट डक्टर or the hospital will criticize or will say something. So whoever are returning back from our courts getting those deaths on one form or the other are talking about not so good about our judicial system. And we all know that, it's just because there are laws such as contempt of court like केही भन्यो, जज like केही भन्यो भने कानुन छ जसको मुताबिक त्यो मान्छेलाई जेल हाल्न सकिन्छ। एक्सेप्ट फेयर क्रिटिसिजम, जजमेन्टहरुको चाहिँ एक्सेप्सन हो, त्यो गर्न पाइन्छ। तर फेयर क्रिटिसिजम कसरी गर्नु हामीलाई पनि साह्रो छ। हाउ टु क्रिटिसाइज अ जजमेन्ट फेयरली इज भेरी डिफिकल्ट थिङ, एन्ड फर अ कमन म्यान टु criticize being fairly is very difficult. Though people do not know this contempt of acts is there, but they fear the court. Some kind of fear that we should not speak against the court, or even for that matter against the police. We hardly see people speaking against what happens in the policing, right? Though there are so many things that people complain about, that this did not go right, this did not go well in the police station or in the investigation, but you hardly find people commenting, except some politicians who are in the opposition. They do comment upon investigation. So it's not easy. हाम्रो यहाँ पनि कतिवटा कन्टेम्प्ट अफ कोर्टको केसेसहरु भएको, and when certain things were written in the newspaper against a judgment, and then the person was convicted also, but ultimately I think he was released on fine or some kind of probation. So speedy justice को अगेन्स्टमा न मान्छे आवाज उठाउन सक्दैछ, न तपाईको हामीले स्पिडी डेलिभरी गर्न सकेका छौं। र त्यसको लागि चाहिँ सीआरपीसी मा सर्टन यो नयाँ लमा सर्टन तपाईको प्रावधानहरु बनाएको छ, जसमा चाहिँ स्पिडी ट्रायल सायद गर्न सकिन्छ। हुन त पहिलाको लजमा पनि थियो, सबै तपाईको है इन्भेस्टिगेसन 24 घण्टाभित्र सक्नुपर्छ भन्ने त सिआरपिसीको मूल हो इन्भेस्टिगेसनको म्याटरमा। 60 दिन 90 दिनको भित्र इन्भेस्टिगेसन सक्नुपर्छ भन्ने होइन, तर त्यतिमा सकेन भने अक्युज्ड जेलबाट बाहिर जान्छ। र त्यो हुँदाखेरि चाहिँ तपाईँको पुलिसले अक्युज जेलबाट बाहिर नजाओस् डिफल्ट बेलमा भनेर यो टाइमभित्रमा हाल्ने गर्छ चार्ज। बट समटाइम्स इज नट पोसिबल, इट डिपेन्ड्स अन दि केसेस। तपाईँले हेर्नुभयो भने थुप्रोवटा सबै लेजिस्लेसन टाइममा आउँदैछ एक्चुअली। पक्सो हेर्नु भने भिक्टिमको स्टेटमेन्ट आई थिङ्क विदिन सर्टन पिरियड अफ टाइम रेकर्ड गरिसक्नुपर्छ, केस सर्टन टाइममा सक्नुपर्छ। एनआई एक्ट फर इक्जाम्पल जो सिजिएम पेस गर्नुहुन्थ्यो, म पनि सिजिएम कोर्ट गरेर आएको। आई नेभर फिनिस्ड एनआई एक्ट केस इन 6 months or even 4 months because I was not just doing an act. So there are so many laws, which says your time भित्रमा सक्नुपर्छ, but it is practically impossible to conclude those cases in time because that particular court is not doing that particular, especially in Sikkim. Sikkim is, I've seen, it's one of those states where a particular court is designated as so many such other courts that it deals with all kinds of cases. And that is one core reason why in our state of Sikkim still it can act 6 4 months, 6 months or 4 months, 6, because it's been long I have left this CGM court. So सक्छ 6 महिनामा, नसक्ने चिज होइन, तर I am not just, that court is not just doing particularly NI-Act cases. And why Sikkim does not have special NI-Act magistrate? Because the cases are not so many that you need a special magistrate dealing with only that case. So we are in somewhere in the middle, the state of Sikkim, that we are neither on the heavy appendency side nor on the very least side. We are somewhere in the middle and we have to manage things. It's a judicial administration. We can't keep one magistrate with, even if it is 100 NI-Act cases, the one magistrate will finish it in 1 year. After that what? So balanced approach. Still Amrama justice it's not very much delayed, including appeals in the High Court, in fact even Supreme Court. So, but still, I think we need to work faster on this so that people feel that justice is not only done but has been seen to be done. And ultimately, your case speedy गर्नुमा जति पनि मेजर रोल हाम्रो कोर्टमा छ, सबै हाम्रोमै छ। Once the charge sheet comes, the entire case file is within our control. So, and there are various reasons why case is delayed. तपाईहरु देख्नु भएको छ। मुख्य reason हो absent of either accused or in most of the cases witnesses. गवाही नै आइदैन भने केस अगाडि बढाउनै सकिएन, सुन्नु त पर्यो हैन। बहुत मुस्किलले त्यो पर्टिकुलर डेट फिक्स गरेको हुन्छ। अब थुप्रोवटा रिजन हुन्छ गवाहीको नआउनु, र त्यसमा एटलिस्ट एकपल्ट त छुट दिनै पर्यो, अर्को डेट दिनु पर्यो। दुईपल्ट विटनेस आएन भने पनि 3-4 महिना त गइहाल्छ त्यो केसको, राइट। कोही बेला अक्युज्ड आइदिँदैन, दो एक्जेम्पसनको प्रोभिजन छ, तपाईहरुले देख्नु भएको छ। बट कतिवटा विटनेसहरु अक्युज्डकै अगाडि उसको बयान सुनाउनु जरुरी हुन्छ, स्पेशली भिक्टिम भयो तपाईको जो आई विटनेसेसहरु छ। युजुअली अर्डिनरीली जो अक्युज छ उसकै अगाडि हुनुपर्छ गवाही, बुझ्नुभयो। अर्को रिजन एडजर्नमेन्ट हो, तपाईहरुले देख्नु भएको होला। एडजर्नमेन्ट कतिपल्ट आउँछ, एन्ड इट्स वान अफ द मोस्ट डिफिकल्ट थिङ फर अ जज टु ह्यान्डल द एडजर्नमेन्ट। ग्राउन्ड्स कोही बेला जेन्युन हुन्छ, जेन्युन होइन भने पनि लेखेर त जेन्युन ग्राउन्डै देखाएको हुन्छ। आई क्यानट गो बिहाइन्ड द्याट एन्ड से यु आर लाइङ। ओके, सो सो मेनी रिजन्स। र यसको लागि पनि प्रावधानहरु छ। पहिलाको सिआरपिसीमा 309 सिआरपिसी थियो, जहाँनिर if the witnesses are present, गवाही कोर्टमा छ भने, if the accused or उसको pleader is not ready or willing to cross-examine, or even that applies to the prosecution, the court may record such statement and pass such orders as think fit. I've done it in 3 or 4 cases where witness has come from far off place and then to ask that witness to go back just because the counsel says I am not prepared. If some genuine reasons are given for not preparing, then with a cost to be imposed, you can call the witness on the next day and give that that day's expenses of that witness in the next date when the cost is given. So actual victims or the actual stakeholders suffer for all these delays. So what has been there, though the provisions are not very, it is just a refined provisions which already existed previously, but still let's hope that it does help to streamline the process of delivering justice quickly. एउटा पहिला पनि भइरहेको थियो, एउटा सबसे इम्पोर्टेन्ट सिआरपिसीमा के आएको छ भने तपाईको पुलिसले 15 दिन इन्भेस्टिगेसन कस्टडीमा राखेर गर्न सक्छ. वी अल नो दैट, राइट? Even in past instances there used to be situations where let's take for example, accused was arrested, he was interrogated for 7 days, thereafter magistrate sent the person to judicial custody. Now police would come with application saying, see, I need to interrogate this person more in the light of these new evidences which I have got. So there was no such provision in CRPC which says what is the period or at what time the magistrate can allow the police to take custody. Total is 15 days. But there used to be certain kind of beliefs or practice that once you have exhausted 3 days or 5 days or 7 days, whatever it is, and I have sent the person to judicial custody, you cannot interrogate. But it did not appeal to common sense as a judge or magistrate. 15 days is there. Why should he know when he has got evidence which necessitates further interrogation of the accused in the custody? So slow or practice developed that okay, you can interrogate, but not in your police custody. You go to jail and you interrogate there. In fact, even till today, some of the courts in high-profile cases in other states are doing this. They are allowing the police to go to judicial custody in a particular room where they are kept, and they are questioning them there. But that still did not appeals to us in a common sense. Police could have interrogated anywhere. Why do they need police custody? Police custody ne किन मागेर लाग्छ त उनीहरुले? मलाई घरमा सोध्दा पनि भयो नि त. And one concept of judicial custody is that it is a place where the influence of police must not be there in whatever matters. Now it's totally under court's control, magistrate's control or judge's control. Though administratively, rule-wise, it is the state or the jail personnel who have the actual control over the accused persons there. But the de jure, in law, the actual control is also of the court. So I used to feel that no. Even again, okay, you go to judicial custody and ask there, right? And then, but still, asking there, the accused will be not in the accused will be in a better position. It is his place, whatever it is, judicial custody. So police custody core nai police station. People tend to speak there out of fear or whatever the reasons. Okay, that is the place which is comfortable to the police to ask questions. So that is the essence of police custody. Otherwise, I could have, okay, you ask me, right? Why do you want to take me to your job? Okay, so because it is much more easier and much more better for police to extract the statements or whatever evidences the accused could produce in police custody. Of course, the law says that any form of torture, or leave aside torture, any form of coercion is not permissible there. But I still think that if you ask a thief, can you tell me where did you keep the stolen goods? He will not tell. Okay, so the people use this methods of causing physical pain to extracting. Police use that, but still, this is why the law says this is not permissible. Can anyone tell me? Even I made a statement that if you ask a thief, kindly please tell me where is the stolen object. Will he tell? Of course, there will always be exceptions who will tell, but that may not be a general rule. Can anyone tell me, at least in our country, or I do not know about other jurisdictions, I've never been to other jurisdictions in outside our country. Can you tell why do this physical pain has to be inflicted to extract something, especially in our country, especially in our police stations? Is there any reason behind that? We should ask the people with LLB degree. So we can begin with Mr. Pradhan. Basant.
normally the accused will not be speaking the truth. First reason is that. So a force in a small amount of force which will extract the truth, I think, for that reason.
But our law says don't do that. So
But
what is the solution then? Where they have provided the solution? See, law will just not say don't do that. They have seen some solution, that's why they say you are not allowed to. Otherwise, meeting would have been allowed. It still occurs in police stations. Anyone? See, the reason is, the absence of training of police personnel in extracting these informations with methods which really works. What are our police personnel trained at? If you look at, they are sent to some academy during induction. Physically test, everything is there. They are made to play sports, shooting, etc. But what about effective, way of extracting information from the accused in custody? So that is mainly absent in our police force. So the only and the easiest way for them is to threaten the person and get things out of it. And as a result, if it works, maybe it's fine, even if the law says something else. But as a result, we have as a judges seen case where there has been made false extractions, to crack the case. It's not that, people say Sikkim is one fine state where everything works well. No, we do find some certain cases where I personally feel the person is not the thief, especially in theft cases, but has been brought as a thief. It's so easy to create a Section 27 statement, right? What you have, you just sit in your sofa at home, sipping tea and write and say accused said it. And recovery is also not that difficult. That is why Section 27 statement has a very less evidentiary value. So now these things all takes in police custody. Now because if the application would come to me after I have sent the person to judicial custody, and if the law is not clear, I would be thinking that what should I do? I as a particular magistrate may think one way, the other magistrate may think different way. It will consume time. Now the law is clear. Even if you have sent the person to judicial custody, you can still be police custody subject to maximum days of 15 days. So this has a little bit of chance of expediting investigation, a very minuscule though. That is one of the changes that has come, which has removed the confusion from the minds of magistrates. Now another thing is, which we all were doing. Now this law, if you see, what has come is a product of many Supreme Court judgments. Because, courts may see Supreme Court judgments or High Court judgments as a precedent and act upon it. The police officers will not. For them, it is only this book. For that judgment, they don't care. They don't know even, the D.K. Basu judgment. Police don't know till date. They don't know any judgments. Of course, there will be exceptions, I always said. And then, for them, judgments are nothing. So what this new code has tried to do is to bring what has the judgment said so far. Of course, what they thought should be brought. The boss of all these laws is the legislature. What they thought fit, they brought into this book. There are so many other things that could have been brought out there, which has not been brought. So, we were, especially during COVID times, if you see, or even in NIT cases where if the accused is from outside our jurisdiction, it was very difficult to get the person to the court. So what we used to do is we had sent summons through WhatsApp if we had the number of, if you had the WhatsApp number of a particular person, right? That was not permissible. It was not barred also, but that had no legal recognition in CRPC or CPC, whatever it is. Delhi High Court did give a order on the judicial side in a particular case, in the facts of that case, saying, okay, you can do it. But as a legal fraternity, we are, some of us, we know that, how precedents work. Every fact has to be seen, whether it matches with my case. Even if single fact is not matching, then it will be difficult to say that it is a precedent. So many of the states did start, delivering notices, summons through electronic process. By this, I don't mean end step, okay? End step is an electronic method of delivering summons. but the CRPC then was still not recognizing whether it is duly served or not. Now the law has come. Communications as this notices summons can be made through electronic means. Now what kind of electronic means is for the state government to decide. And I'm quite sure unless someone wakes up in the state, this provision of which electronic modes will not come before us. Till the court faces the difficulty and points out to either the High Court or the Law Department that this is causing a problem, kindly notify which electronic means you all would recognize. Then only it will come. People will be sleeping. Everyone is happy that from 1st July it has come. But there are so many things that the state needs to do on this. It should have come by 2nd July, to my understanding. These are the things. Right now we will be waiting. Now the judge will still be confused whether WhatsApp is a particular mode recognized, Telegram, SMS, okay. But nevertheless, the law has recognized these forms of delivery. It appears that now N-state is maybe going to be obsolete. If it says, okay, through this particular, usually they will recognize all this Telegram, etc., which is Indian made, and people say, they are much more safer than WhatsApp and etc. I do not know the reason behind it. I still see WhatsApp as one of the most secure forms of communication. No one can crack it. And you may have seen in, televisions, in certain cases, especially Sushant Singh case, high-profile cases, WhatsApp chat. These chats are not recovered after deletions, okay? These chats, the phone was unlocked, WhatsApp was opened. Just like you give me your phone to me, if you open the unlock, I can read your WhatsApp chat. No one can crack WhatsApp chat, and even if it is deleted, it does not stay in your phone. It stays in the server of WhatsApp. So, so it's still one of the secure form of communication. I see no reason why it should not be adopted as one means of communication as provided under the law. But still some Indian apps are more encouraged. They are also well and fine, but it has been very less reach among the people. So that is one thing that has come. We have examined accused through video conferencing. Have you? Okay, examine. Yes, ma'am, Jamna. Have you ever examined accused through video conference? Frame the charge? Yeah. So this, we used to do it, but it had no particular provision in the law, right? That has been given a legal sanctity in the new law. Now I can easily examine accused through VC without any fear of some superior court telling what you did. It's not there in the provision, because law can be interpreted so many ways, right? A particular court might say, oh, very good, the person did a very good job. He adopted electronic means, a very forward judge. Some might say, no, this is not written in the CRPC, how it can be done? At the lower level, judges have to take care of so many things, as such what I said just now. And one of the biggest fight that the Indian system or the judicial system still considers is the consistency in what is going to be said in the superior courts. Okay, we still find it difficult to know that what it will be said in these particular circumstances. And especially it is always, that is why it is said that precedents should be followed into. But of late, there has been those who are working as readers and stenos or deputy secretaries or additional who have been dealing with the courts. Of late, we have seen that even the judgments that are coming may not be consistent or according to the precedent, and we have read in media or judgment where it was criticized that a particular bench did not follow a particular bench judgment. So consistency, because of that the magistrate would get confused. So now that is clear, I can examine the accused through video conferencing, no problem, no one can say anything. In fact, in one of the cases, I had examined the accused, I had framed the charge through video conferencing. That was the first time I framed the charge through video conferencing. Now, because the thing was the accused had about 38 cases in the entire country, from South India to North India, from West to Northeast as far as Tripura. And then it was very difficult to secure him physically. Whichever judge was successful in securing him physically in any part of the country would not leave that accused. So the trial was getting late for me. It was 100 plus witnesses, and I consulted many, and many of them said that a judge, an accused should sign the paper on which the charge is framed. Yeah, it's written ROAC also. I still remember. It's still being written. But when I read the CRPC, it says nowhere that the accused should sign, and the magistrate should sign. It says so. I took advantage of that provision and framed the charge for the accused through VC, and later on, I got him somehow after many attempts, and I did not leave him until the case was over. Many police officers, jail authorities from other states came asking, this is the production warrant of certain court. We need to take him. I said, no, I won't leave till my case is over, because there is a provision for that also. So this will, to examine him through VC, for me to make up that mind whether I should do it or not, I think it took about more than 1 or 2 months. I did not think every day about that, but whenever I got time, then it used to come in my mind that I have this case. How should I examine him? I was pretty sure he will not be produced physically. So I lost about 1 or 2 months in trying to prepare my mind that I'll frame the charge and read over it to the accused through VC, and will not obtain his signature. So now the law is clear, you can do it. So, it's kind of saving on those 2 months. Had that provision been there, I would have blindly closed my eyes and said, okay, let's do it. So my 2 months is saved. So these are certain small provisions which has brought about certain changes in expediting the trial. Another thing is FIR. Still police will insist, but it will be for people like us who knows if someone comes to you and says, let's say to Basan, who is a law graduate, or postgraduate, I do not know, but still you are minimum law graduate, and then, see, I want to lodge this FIR, police is telling me come to police station. In fact, now the old CRPC, 1973 onwards, which was there, we as a system, even as a judicial system, could not impress or change upon the police that FIR in writing is not necessary. But still till date, police officers ask FIR in writing. It is their duty to reduce what you are saying into writing, read over to you, register it and give a copy to you. As simple as this provision, police never followed it. In my 12 years career, I did not see a single police station in Sikkim doing it, except in POCSO. You know why they did in POCSO? Because now they are saying, no, the team is small, POCSO Act. Now, for them, POCSO Act is something which is far bigger than CRPC. Of course, it's a special law, but CRPC had an equal importance when it came to registering FIR. So this was not being done. Now, now, why I am saying this is that, now electronically you can lodge FIR. Now let's see how many police stations are proactive to accept it. But one thing I did not like about the change in here is it still asks the person to come to police station and sign within 3 days. What's the point? The only thing I can understand from here is if you want to lodge it immediately, right? And this provision is going to be attacked very heavily by defense. Let's say, as you know, I am somewhere in West Bengal, and certain thing happened at my place. Anyone can lodge a FIR. It's not that the person who has seen it, though the person who is actually conversant with the facts would be in a better position to lodge the FIR, but anyone can lodge a FIR. And then, someone from my house calls me, this has happened in the house, theft has happened, trespass has happened, we have caught the fellow, or we had caught it, he escaped. They'll always look upon the people who knows law if you are there in the family, right, or someone who is educated. Then you will be under pressure to lodge now, okay, lodge a FIR. So I can do that from Siliguri. But it's still saying you come and sign it. Now, I believe that, it ought to have been kept, that, okay, that is acceptable. No need to sign it. You can sign it whenever you like, if it's really required. Now, they have given something, but on the other hand, what's so beneficial about it, I did not understand, because, how many times I'll be in Siliguri? I'll be at my home only. So usually I'll lodge. If I go to police station lodge, if I'm making a provision which is helpful, it should be helpful in real. But still now, the law is there that you can lodge FIR electronically. I don't know whether they will keep an email or there will be software system, I do not know, but it can be done. Now let's say if certain modes are recognized, through that mode also you can send it. I'll only go through the major ones, okay? One more thing, the power of the magistrate, first class judicial magistrate, the earlier power to impose fine from 10,000 to 50,000, it has been increased. This would be helpful to pescers because pescers are half judge, isn't it? But one thing, always in the court on the lighter side, amazed me was, that happens. We have studied law, we are doing some certain cases are very interesting, but you look at this tenor, very disinterested in the case. Right, look at the pesca, because someone is telling so interesting, you have no one around as a judge to talk. You hope someone would also be interested, then you look at pesca. Pesca is also not interested in the case, of course interested in their work. But what is happening in the case, no one is interested except the judge, Certain cases are very interesting. But the same face, there's no excitement there. If I have done it. Now one more thing, which is also time saving according to me, is that, if the offense is punishable by 7 years or more, then a mandatory forensic investigation has to be done. Police are usually doing forensic investigation, but on their own ways. And sometimes, they do it very late, and it takes time for completion of investigation. So now if there is a mandate, 7 years and over means some serious offences and heinous offences. Now if there is an initial mandate to do it after the registration of FIR, collection of evidence in the scenes through forensic means, that saves a lot of time. We have done it initially, right? But this requires a very good, forensic team. So the law has been made. There are huge demands also that this law is making in terms of resources. We need to have a very good forensic team, forensic lab which can give you results overnight. Suppose there is a, some kind of thing you need to examine, and if you do not have facility out here, it's pointless. Though we have regional forensic science laboratory, it's been quite a number of years, I do not know whether it has improved or not, but handwriting was available there. This chemical examination of substances, blood group and so examination. Ballistic is still not there, right? So many things are not there. DNA is not there. One of the most important things. So there is a demand. This law has come. It's not just we can be happy with this law has come, but the law has created demands also that these things should be there. So let's see how fast that will be established. If you still have to send forensic to some Tripura or some Chandigarh or Bhopal, then it is not helping us. And one more thing, that is, Directorate of Prosecution. Is anyone aware of what is this? Sikkim doesn't have it. As far as I know, doesn't have. Directorate of Prosecution. Directorate now is same as you all have PPs in your courts, right? Who is the head there? Who controls prosecution? Any idea, anyone? Prosecution means there's a case gardasan. Yes, Mr. Chumchung has been working quite a number of time in the court. Who controls the prosecution as of now? What is to be done? Are they even aware what is to be done?
Public prosecutor and the court inspector.
But we have seen, with all respect, we have seen who guides them. If I can use a better word, I have to be quite, witty also out there. I cannot use certain words. Who guides them? Who controls what is to be done in a prosecution? We have seen prosecution cases failing so many times. How many acquittals? Have you ever heard conviction from a judge? I used to get dizziness when I pronounced conviction. Really? Shock. लाग्छ आफूलाई. So there's no controlling mechanism of prosecution. The PP goes its own way, the police goes its own way. The higher echelons of police, from Supreme DSP and above, goes their own. They have their own notion of investigation. SIs who are more practical on the field, they are a little better notions they have about investigation. Prosecutor thinks the prosecutor's job is only to plead before the court. And they try to show some of the judgments also, which is police and prosecutor should not be together. It does not use the word together, but they interpret it as together. The judgment simply says that the police and prosecutor cannot be hand in gloves to defeat justice, which was in the facts of that case. Now it is interpreted as you stay behind that wall, I'm staying behind that wall. I do not want to get anything on my head. The moment any responsible person who has been given certain responsibility starts thinking about their head, no job is going to be done. Your head will have lots of cuts if you have to really do things responsibly. So there is no formal mechanism of giving direction to the prosecution cases. Charge sheet comes, prosecution says there is prima facie case. Except in few cases, prosecutor does not say anymore, Your Honor, there is prima facie case to frame the charge. Even will not tell this section. Okay. And defense, even when nothing is there, they might say, I'll contest. I'll prove my innocence during trial. And in some other cases, even when everything is there, sufficient to frame the charge, they'll still argue hell-bent, and boring the judge and wasting the time. When the judge has already made up his mind sitting here, because we have to hear, right? Whatever you say, I'm going to frame the charge. And as a judge, we need not write more in frame of charge. I find sufficient materials to presume that the accused has committed the offence and framing charge under so and so section, right? So, of course, the process of creating directorate of prosecution, I think it's section 10 in the previous CRPC, I'm not sure. Okay, 25A, in the previous one. Directorate of prosecution, the file was doing, but this video sometimes, what it does while speaking, but still, yeah, this is an academic place where we can discuss certain things, but still, what is the fight in this directorate of prosecution? Why it's not coming up? At least what I saw was, who wants to become the director? Everyone wanted to become the director. That is why it still did not come out in many of these states. And you know what has been done? What does the CRPC, previous CRPC, say regarding the qualification of a director? Anyone? It says an advocate of at least 10 years practice. Which means 10 years practice is not less. The person has known the court. The person knows how the judge works, how things move around inside the court. But retired police officers want to become directors. So my view was, if police is to be brought there as a director of prosecution, then what is the change? Police is still heading the prosecution. So it requires a person or persons who has the in-depth knowledge of how cases fail in the court. It could be a police officer, no problem, but you cannot just pick randomly anyone and put. And states have amended CRPC to make police officers head of the prosecution. Done away with what the legislature thought of, because CRPC is in the concurrent list, I think. So state has all its domain to amend it. And then most of the states have included police officers, giving some good job to retired personnel, instead of thinking about how you should be able to increase your conviction rate. That apart, now this improvement in this law is it seeks directorate of prosecution in every district. Earlier it was only one major director staying in the capital and controlling everything. The job of the directorate of prosecution or the director is to see whether the cases going to the court are proper or not, whether investigation has been done properly or not. What will the judge look into the materials for a particular section? Right, so this, what it will do is, there are often in the courts, applications. It may not be in our state, but in other states, there are frequent applications or, supplementary charge sheets coming in. Because, the 60 days and 90 days, how do, there's a way of bypassing it. And, the prosecution usually bypasses it by giving you bare material upon which you may frame charge. Or you may discharge also. And we'll write in the end. Now, at one point of time, it had been routine for police to write in the end, that we are filing charge sheet that and we'll file supplementary charge sheet if required. Right, so, and in other states, a lot of applications would come, this is being done, and kindly call this, They, to save 60 days and 90 days, they did file the charge sheet, but once the trial begins, the investigation can still go on, there's no problem. Earlier, it was without the permission of the court. Now, if the trial begins, the law says, the new law, that permission of the court is required for further investigation. So this will be also time saving, application should be filed, and the judge, the moment it comes to some moment, judges involved, there's an application of mind. So things go in a proper way, much proper way than if you just allow the investigation agency to go by themselves. So this is one of the places where, unlike previously where the judge had no role in investigation, now a little bit of role has been given that, okay, if it's further investigation during trial, you take permission from the magistrate. This also has a little bit of expediting the trial. Now another topic that says to me is assessing the role of court staff. What this could be? I think you all can tell better on this. I'll tell my perspective about court staff, what it can be done. I could correct one. Pauline is down there. I was seeing someone. Okay, the two at the back with deeply engrossed since morning in mobile phones. Or is it something else, some work of art? No, I'm just making a lighter statement. I don't mean, you can see it, no problem. Even I was seeing it out. Okay, I do not know what a court staff can be of some role in the, directly in this law, but what I can tell is, the role of the court staff assumes importance. People talk so many things outside. They will not only talk about judges. You may be hearing about what people talk about judges, but we hear what people talk about staff, the common people, right? So no one will come to you. There are very rare people will come to your face and say, you did this, you and that, right? So हामी हाम्रै कुरा त सुन्दिउँ न, हाम्रो पनि भन्छ नि, we all know. We were warned when we were in Chandigarh Judicial Academy that before bail, don't allow a lawyer to enter your chamber. What would the lawyer tell? Can anyone guess? Yes, Rinchen, no? What possibly the lawyer could tell, maybe. We were warned that don't allow a lawyer right before bail hearing inside a chamber. Because in those states, the practice was that, we have to give something to judge. And in fact, the lawyer might be saying, he takes 80%. I am only taking 20%. So give me. The poor fellow doesn't know. Okay. Now he'll go thinking judge takes, right?
Even if nothing is given,
Yeah. Yes. And we will, okay, so someone comes to us and let's say Pesca comes. Sir, why would we say no? Lawyer would come, hello, good morning sir, how are you? Just wanted to wish you good, and the party is outside, I wanted to wish you good. Oh, that's all you have? Yes, I don't want to disturb you more. The fellow goes outside our chamber and the person sitting outside sees him going inside it, has the potential to, enter the judge's chamber and says, see, I did it, and bail we can often predict what will be the outcome. There are very rare cases because bail is a rule, jail is an exception. Right? Bail anyone can almost predict that it will be granted. So at least the person will take certain risk also even if it's not granted. Even if it is not granted, we all have studied law. Even if I was a lawyer, maybe I would have said that, not without going to the chamber of the judge, I would not have gone. But if I would have said to a party that, you will get bail and the bail was rejected, I would have still something to say to him. Don't worry, next time, pakka. The party would had to agree with me what I am saying. After all, I have studied law and I am that party's spokesperson. So that was what we were warned at. And then, what about the staff now? do anyone tell anything? Of course, we as judges or the administrative district judge, we do not know what's happening in the corridors, right? And then how people are treated. We often find people coming to the courts who do not know anything about law. I have seen in the court of Gangtok, it usually happens in Gangtok. Doesn't mean it doesn't happen in other districts. People are more innocent in other districts. I've seen a lot of times in the Gangtok corridors, during peak hours, we don't hear or see anything what's going on outside because there is a lot of movement of lawyers, the accused being taken by the prosecution people, the jail people, our own staff's movement, some even running. Okay, but still in that situation, you have to maintain pin drop silence. That's the rule of the court. Still, it's very difficult to find out what's going on outside when you are concentrating in your case inside your courtroom. So, but once the crowd becomes sparse in the court, in the trial courts, you do hear something what's going on outside. And you will see so many times people, carrying one paper in their hand. Some people who have not ever gone to school, walking in the corridors, not knowing what to do. And I've seen my staff saying, Boliong. Right. So the max what can the staff can do, you cannot do anything directly on these laws. You have that person. It's like you going to a hospital and looking for some. We are faced in hospital. They don't know who you are. Okay. So we should not see people who come to the court by the status, but help everyone. But in that very place, if it was someone with tie and all, or someone well dressed also, with all gold bangles or whatever it is out there, people would not react that way. Right. So that's the maximum a staff can do. I have seen a lady had come, and she was saying something outside. I heard one of my staff saying that, I don't know. Then I said someone to call that lady because she was speaking through my door. My cases were over, I was dictating her. And I asked her what happened. She said that, I don't know, my son had a vehicle, it met with an accident, he died. And police said me to go here. And she had come for release of vehicle. And what she knows, right? She could have, I think she met so many of the people, known people, no one offered her any help. So what can we do? We have to ask them to file a petition. I cannot release a vehicle without petition. So at the most we could request a lawyer. I requested a lawyer and said, okay, you do so many high-profile cases, you earn a lot. Of course, I have some cordial relation. We cannot tell this to all the lawyers with whom we have some kind of cordial, professional relationship. We can always tell you file this pro bono, free of cost. Then he filed a vehicle, was released the next day. Okay. So there are so many such people who come there. There's a concept of judicial service center. Judicial service center means people should be helped out there. There used to be a help you desk also, which is usually not manned by anyone. Desk could be there. So these are the things we need to care of. We are getting salary for doing our job. Of course, if you are in a hurry or if you are in some important work, you can ask the person to wait till you come back or something, but do come back. Don't make the person waiting. If you have said 10 minutes, the person will wait you for 1 hour because usko kaam banana hai. So that's the most I think it says. Otherwise, I didn't find anything in law. What the staff would do directly in the law. Of course, another is those are involved in the judges inside chambers to maintain the case file properly. One of the worst thing is that case file not being found on the day the case is listed. I have faced that situation. It was not lost. It was untraceable for that moment. The witness is there. The judge is sitting there. The pesker says, you silently, sir, case hai file. What to do next? File when the witness goes, I have done these cases. And taking file from the either prosecution or accused and saying, okay, let's record this statement, we'll see it later on. And we have found the file also. This is one of the crucial thing about staff's role in the, you may not be playing direct role, but you have such an important role to play. And then the only course if a file is lost is, and believe me, nothing is going to happen to a judge if a file is lost. People may be having an impression. I'll trouble the judge by throwing the file. Of course, judge will be questioned, but fact will be found out. It's not that the judge will be blamed. for losing a file. It will be the actual person who had the role of custody will have to be responsible in the end. Judge will take the overall responsibility, but a fact finding will be there. And of course, this is one thing. The next thing is, what can be done? We can reconstruct the case file. There are judgments. We can reconstruct the case files, and the role of the digital files now is very important, because once it is digitized, unless the server everything goes away, the files will be there. So that could be your role. Other role is, yes, I personally believe that sometimes some of the court staffs are so experienced, having seen the courts, that you might be able to help new judges also who have come there. You may feel free to help, but you have to see a person's personality also. What kind of a judge person is. Everyone is not, all five fingers are not same. But of course, even I have asked when I joined service, Peskars, that we forget what comes next, even in criminal process. Okay, I have framed the charge, next what? Even after being very experienced, without framing the charge, I have summoned witnesses. And the witnesses are before me, and the defense tells me, comes ahead and tells me, sir, you haven't framed the charge. Then now whom to blame? And to blame. But I blame the lawyer also. Why you did not tell me on the last date? When I was dictating that, okay, issue summons. This was not because of, I didn't know the law, but because of work, so much work there, you tend to forget. In this time, if you are aware sitting there that I have not framed the charge and I am still dictating, summoning the witnesses, then you can tell to the judge politely that, sir, we have not done, or madam, we have not done this. But if you go and say outside, the judge charge, because that is the more tendency. You feel like saying, but not to that judge. So, looking into the nature of that particular judge, you can be helpful in these things also, right? It's not that every time, you remember. Now, role of the trial judge in plea bargaining, summary trials, trial in absentia under BNSS. Now, in plea bargaining, the earlier law also does not give much role to the court of SLB procedure. But everything does not happen, need not happen according to the law unless you are not violating the law. In the court, you can always tell the party, this is the case, this is going to be. It's better if you plea bargain. But plea bargaining is not working in our country because, what is the incentive of plea bargaining? Even if you are prescribing punishment for it. The present law also says, I think 1/3 or 1/4 of the prescribed punishment. No one wants to go to jail. And the prosecution case is so weak, why should I plea bargain? I'll get acquitted. Right? So if the judge says, okay, nothing is going to happen to you, then plea bargaining will be successful. Otherwise, it's better in the present scenario, from the viewpoint of accused, to get an acquittal than to plea bargain. Now, why plea bargaining is successful in the countries like USA? So, only reason is they have foolproof evidence against the accused. They don't file cases without any evidence in the court. That is why they have such low pendency to my belief. Offences do happen there, more than here. But not all cases reach court there. Those cases reach the court and investigation is very, very good. There is no chance of accused escaping. Now, if I as an accused would know I am going to get convicted if this goes to trial, I would definitely plea bargain. That will give me something less than what the judge might give me in the end. And judge might be furious also during the whole trial, knowing that the fellow did not plea bargain. Judges are also human. It's not that the mind walks in isolation. That the accused could trial कसरी चल्यो, how did he behave in the court? This all matters in the end while conviction, right? So if the judge feels that I gave him an opportunity of plea bargaining, still tried to contest despite this good evidence, I'll go with the maximum punishment. Because that gives me a belief that the person is not going to reform unless I put some harsh punishment on him. So plea bargaining doesn't work in our country, it's not working in our country. It may work because the charge sheets are like floods in our court. There is nothing the person has said, still the charge sheet comes. Final report only comes when the police are unable to crack the case. at all. They are getting nothing. Right, so even a slight thing they file charge sheet, which is ought not to have been. That is why this Directorate of Prosecution is so important. But I don't know if it becomes some kind of a usual body replacing the police officers of DSP, SP rank, then it's the same thing that is going to come up. These bodies does have purpose. Law has been made. The legislature is not saying, it is we who is not performing. The law has given it. Make Directorate Prosecution. Are they saying, make it for the sake of making it? They mean business. The legislature means business. But if we don't sell our things, then how there is going to be business, right? So that is there in the plea bargaining, what I have to say on that. And one important thing that has come is trial in absentia. Okay, I'll ask Mr. Rich. Karma Dicha. What would judges do when the accused is absconding? Sessions process भन्नु न फर्स्ट accused हराएको छ but case is there, no? एकैजना accused छ, भाग्यो.
No.
हजुर.
So for individual issue, again, then 182, 183,
त्यहाँबाट
then we issue summons
to whom?
to prosecution witness.
And then
Then after total examinations, then we send to courtroom, the record section.
okay, very good. He said the correct process. And then, but this time it says you can pronounce a judgment in absentia. Right? Now, I'll tell you something later on. The provision says now in the absence of accused you can also pronounce a judgment. I believe it's a welcome step because sometimes what happens is, what was the earlier procedure? You would send to the record room to be placed before me, to be placed before the court as and when the accused is arrested or appears or is produced before, right? Then, open warrant is issued and one finds in some cases the accused are brought. Now I have to do the same thing from first as per the law. I cannot use that previous evidence which was there unless the witnesses have died. Under section 32 people think it's only dying declaration. There's more to it than dying declaration. On the 32, those statements become relevant. And then, one thing I do not know how the law will move further in this context because, this is my concluding portion, I'll take about maybe 10 minutes. Though we have made changes in the law. Now the most difficult thing after this new law has come is to remember the sections. I think I did not quote any sections today because I don't know what sections are here which has replaced the previous ones. Section numbers have changed. Okay, that would be one of the most difficult things for us, for all of us. It will take a lot of time to remember those sections that no, it is this section. Just few days back I saw a meme which says now we no longer can talk about movie Chachi 420. I think it is something else, what the section I don't know. 420 for us every time meant, in jokes also among friends or when we are talking, it was 420 here. And no one wanted a vehicle number with 420, mobile number maybe. It was such a board section. 318 now. So Chachi 318. Okay, so yeah, things. But if you see, there's not been much changes. I'll tell you one thing about is we had IPC was a Macaulay court, right? He was the father of that IPC. CRPC also there was in 1800 something. There was CRPC, which was later changed in 1973. Indian Evidence Act 1872. Most of the laws are prior to 1900. To my understanding, these laws were still performing. 1860 Indian Penal Code, 1960. About to be 2060, right? Still worked. So that heritage this law has. And what is our criminal jurisprudence? This has used, now I am coming to the critical part. This has removed the word British India. There is no British India anymore. Of course, rightly so, that those definitions are not usable anymore. It's useless. Government of India Act, 1935, not required. Some charter words not required. Okay, But you cannot change a law just by a statute. Procedural law special. Now you may change a special act, like if you change POXO to something different tomorrow, it will be very much workable tomorrow also as is workable today. But procedural law is something which governs every aspect of the entire trial. The POXO Act does not govern trial at all. It's more of a substantive, of course some procedures are there. But CRPC, IPC and Indian Evidence Act, this governs the trial, how the court moves. So the development of law since the British time, Privy Council judgments are still referred to by courts because they are very good judgments. If you see in Indian Evidence Act, you will hardly find any Indian judgment which does not refer to Privy Council judgments or the judgments of those benches which was there earlier. The law has been set in the early stages of this laws coming into place, and upon that it has been built till date. Okay, there are hardly new interpretations which does not have a base in our jurisprudence years ago. So no matter what these sections say, the presumption that the accused is presumed to be innocent till proven guilty is still there. Prosecution have to prove the case beyond reasonable doubt is still there. Benefit of doubt is still there. Okay, process of examination of accused is still there. The structure is there. The principles that we have till today, this will not overnight, develop new principles. Right? Like I said, now in absentia we can pronounce judgment. There will be a lot of litigation on this in future. Because no accused wants to. Because the previous principle is what? You cannot even take evidence in the absence of accused. Now that provision was making an exception just to take it for the purpose that one fine day if the witness is not traceable, if it's dead, then use that. That was the only purpose of recording statement of accused in his absentia during exponent. That's the only purpose. Okay, now purpose, now when you are pronouncing a judgment, what is it? Is it a play that you just pronounce a judgment and it will not have any consequences? As per the law, judgment should be having certain consequences. Either you are guilty or acquitted. Now acquitted, no one will come back, everyone will be happy. Prosecution will never appeal. And then, but if convicted, the accused will say the evidence was recorded in my absence, I did not have the chance to cross-examine, and it is unfair. Now what our principle stands till today is really unfair. Right, but yes, this will lead to litigations, and of course, looking into the facts of each case, I think the judgments will come saying that no, in this case judgment is alright. Right. In this case, no, you set aside the judgment. So and so forth, it could be there. We have not lost the core of these laws. The IPC, the CRPC and the Indian Evidence Act, now named differently. The core principle legal jurisprudence remains the same. Okay? So the previous laws, I do not know when will a certain time come when we can throw away the IPC. Can you throw away IPC today? Why not? When it's new law, why you cannot throw away IPC? I want to ask. Or samjata. Why we cannot throw away IPC, Indian Evidence Act and CRPC? Even for those cases, let's suppose, and assuming it's registered today, has got nothing to do with the old ones. Can we clean our library, Mr. Indrajit? Where is it? Where is it? Why? Now let's hear from you. Why you cannot clean? Let's throw away these books.
For implementing these new laws, we have to we need to use RA1 also. So we need to
RA1?
Earlier.
Okay. Why? That's why I'm saying why. I said that. I made that statement. Why?
The knowledge we have learned from the earlier laws should be compared to the new ones.
Yeah. As I said, the principle remains the same. How will you decide 302 with the previous decision than IPC? So it is going to be a little bit of difficult task. We'll have to keep two books. I'm not sure when we can throw away IPC. At least in my career, I don't think I'll be able to throw away. I have to keep it. Because since then also, because the changes in these new laws are not so substantial that it has the capability of developing principles in law. Okay, so some particular facts, it may develop a precedent, but this these three statutes has no potential to develop legal principles. So our legal principles is going to remain forever the same unless someone rewrites this. This is not a rewriting. This is rearranging and adding something. Okay, so now we are trying to be brainwashed saying that something new has come. Of course it is new. It is new. Because now when people ask, okay, when you say new, it is really new. But that's what I said, we cannot clean our libraries. At least I said in my career, I need IPC, CRPC, and Indian Evidence Act to refer to what has been. In fact, I need more because some of the things out here are still has not gone through the test. So on what basis I'll be testing? I'll be testing on the basis of the laws that existed earlier. That is our law. That is law which has stood for centuries on that accused shall be presumed innocent until proven guilty. So can I say that's not applicable in this one? Right? And these have deep roots down there. This is just one branch, suddenly it grew from the trunk itself. I would say that these laws have grown from a very old tree. Somehow they managed to grow in that trunk, trying to put their roots. But the feeder is somewhere else, the real roots. So we are going to have difficult times, especially with the readers, I think, in coming days, because the judge will constantly tell me what is there in the previous one. Show me that section. And you'll be fumbling with those sections. So how is it different from than before? There's a lot of questions are going to come. Within the core legal fraternity that will be actually dealing with it, especially with police officers also, they will be in the initial stage getting confused because we have seen that police officers' interpretation is different. In fact, they don't interpret; they do what is being told to do. It comes to us, and now we have to explain. This is not this way. Come and do something else and come. A fellow will get fed up. The court sending back again and again. Many of these such things are going to occur, and in these processes, another role of staff will be the judge could be getting furious with you because police is not working their way, and you have so many cases listed. Ultimately, the judge will scored is the one who is the nearest, especially the Pesca, and the Pesca will go red-faced to his chamber and tell Steno, hey, you didn't do it. And Steno will tell someone. So these things are going to happen. Be patient. It might bring some kind of impatience among the judges during the peak trial periods. Even for as small as not finding the section which he is looking for. So that's going to be the next level of our trial for some years, I guess. It's not difficult, it's absolutely manageable. The changes, the only thing that I personally feel is I need to know what are the sections in this, the numbers. Rest, we need not worry actually, if we sit with cool minds. So this much I have to say, and then if anything, we can discuss. Yes, ma'am. Okay, I think cognizance you said something. Okay, cognizance is also there. I still have 10 minutes. Okay, in what sense? Remand, I think every prescriber knows. Who doesn't know? Oh, रिमान्डमा चाहिँ नि तपाईहरुको पहिला त के थियो नि त पुलिसले पहिला 7 दिन दियो अरे म्याजिस्ट्रेटले जेसी पठाएपछि दिदिन भन्थे म्याजिस्ट्रेट मैले भनेको या त मैले कोही बेला सारै भयो दिनु त पर्यो नि 15 दिन छ जेसीमा जजमेन्ट पनि क्लियर छैन यसमा जेसीमा गएर सोध ओके द ओन्ली केस हामीले जेसीबाट निकालेर दिदै थिए त्यही पनि अब नजाने जस्तो हुन्छ द्याट्स हाउ वी ह्याभ टु सी ल यु नो व्हेन FIR is registered, accused went absconding. Oh, no, sorry. Accused has 2 cases. In one case, it was registered afterwards, he is in JC. Now, police have a right of interrogation because he is there in JC in another case. Police want him in another case to interrogate in police custody. Now, what should they come with an application? Now, what was the best way to deal with it? They did not file any application to arrest him or to interrogate him. They filed his production warrant for the purpose of investigation. Right? That is absolutely allowed. Can allow that. Or he or she was produced in another case from the court, and the police arrested him there. Now, once that arrest is there, that remand process starts. Even it's another case. So on that basis, okay, he's arrested. I used to write that accused arrested in another case. And so I did not mention in that case he's in JC and whatever it is. Human granted. If someone is so query about what I have done, can come and match why will I write a history about what I have done, right? So this is one, and now the judges can give police custody to the accused, even if he has been sent to JC, bring him and give it. Specific provision has been made, and then, but within the limit of that period. Okay? Beyond 15 days, no, forget it. You can't get it. I think it's still 15, right? Still 15. And cognizance, especially for pescers, I have seen a situation where cognizance orders were written by staff. And what danger lies in that, that maybe in some other courts is covered. Because it's a regular order, cognizance order, if I'm not wrong. Usually the court, hardly there are cases where cognizance means when the case file first comes to the judge. Right? Those who are not aware of what I'm telling, cognizance. Case the first comes in, judge comes first time राखिन्छ त्यसमा हेरेर यहाँ रहेछ भएकै रहेछ भन्ने त्यो माइन्ड बनाउँछ जजले द्याट इज कग्नाइजेन्स चार्ज स्टेजमा भएको त भन्दैछ हेरौँ त हो बुझ्नु नि चार्ज बनाइसकेपछि भएकै रहेछ लु त प्रुभ गर त सो कग्नाइजेन्स मिन्स when the case file comes first time to the judge will see whether there is अपराध छ कि छैन अलिकति भन्ने हो भने भयो पत्याइहाल्छ जजले त्यो जजको पत्याउने जुन चाहिँ लेभल छ त्यो बढ्दै बढ्दै जान्छ पहिला अलिकति पत्याउँछ चार्जमा अलिकति बेसी पत्याउँछ त्यहाँ एन्डमा जजलाई विश्वास गराउन धेरैवटा कुरा भन्नुपर्छ सो एट द स्टेज अफ कग्नाइजेन्स स्टाफ्स प्लिज डोन्ट राइट द अर्डर्स द्याट विल क्रिएट अ प्रब्लम because when I sat after I came to a particular court on transfer I sat even those cases whose cognizances were barred on the law. Now what to do? Cognizance has been taken. Right, there are so many cases. You cannot take cognizance offences against marriage. There's a specific provision. Who is to be the complainant and what? Can a charge be framed for offence of defamation on a charge sheet? No. Cognizance is something which can be stopped at the stage of cognizance. But cognizance taken of so and because it's a routine order, staff wrote it, judge signed it, and cognizance taken for so and so offence. Can you take cognizance against a public servant without a sanction? Absolutely not. Many argue basing things on P.K. Pradhan judgment. Cognizance is barred. Forget about that judgment, not even required. So there are certain offences. I do not know what the new law. I think it has not changed. Where cognizance is barred. Defamation against like Prime Minister, President. Procedure is different. Someone has to give sanction for that. There are so many. That is one. For offences against criminal conspiracy against state, it's very, very much ignored. No court shall take cognizance of offence against criminal conspiracy against a state, except on the sanction of the district magistrate. But routinely the 120D is coming in. Now this hampers the track, right? So cognizance is a job of the judge. Just lay your hands off it. Unless you have become so expert that you can tell. Some of them are. That will help judge, you can draft it and judge can read it and sign it. So cognizance, Matthew, and with the rest up to the trial, all pescers know what happens in the court, right? So, anything? Actually, it's really boring because not for me, for you all. I'm enjoying because I'm understanding what I'm saying. I've studied that. But really, for one who have not studied law or have not really taken care of what happens in the court, despite being in the court, it's really boring. Just like we would have for someone speaking on mental health. Okay, after some time, it becomes so difficult. That's the truth in the end. Satyamev Jayate. Okay, thank you.
Everyone. So my topic is under Bharatiya Nyaya Sanhita. Okay, I will not be talking much in detail, but then yeah. Okay, so this is is an overview of Bharatiya Nyaya Sanhita. So we can see that Bharatiya Nyaya Sanhita which is an Act of 45 of 2023, which came into effect from 1st of July 2024. It was notified in the Gazette of India by the SO 850E of number 811, and it was notified on 23rd February 2024. But the only provision which has not yet come into effect is section 106 subsection 2, which is hit and run case, which I think will be notified later on. Okay. So what was the need for change from IPC to BNS? Now IPC 1860, as we know, was framed during the pre-independence British area, and it has been going on for almost 15 decades now. But then it has not been at par with the evolving and the new changes or the offences that have come into light. So in order to tackle that issues, this new IPC BNS has been framed. Bharatiya Nyaya Sanhita, as we can see, is simple translation garदाखेरि चाहिँ it can be Indian Justice Code. Indian Penal Code like say now it has been Indianized. For पहिला चाहिँ what was the main core is that it was focusing more on punishment. Now the focus is more on nyaya or justice, as we can see. And what we can see here is now more importance or precedence has been given to the offences which are against women and children and also against the state. Earlier, what the preamble used to state was, whereas it is expedient to provide a general penal code for India, now it specifically says that it is an act to consolidate and amend the provisions relating to offences and for matters connected therewith or incidental thereto. So we can see that a number of changes, like some additions and deletions, have been made in this case, and we can see that earlier in IPC there were 511 sections. Now in BNS there are 358 sections only, because most of the sections now have been clubbed under one section under many subsections and everything. And now the total number of chapters have also been reduced to 20. Earlier it used to be 23. A separate chapter now although has been inserted for the offences against child and women, which comes under chapter 5. The number of offences earlier used to be 483. Now it has been reduced to 464. Like you can see in the screen also, cognizable cases पहिला IPC मा 315 वटा थियो, now it has been reduced to 294. Number of cognizable, non-cognizable offences earlier used to be 145, now it is 147. Bailable offences 259 वटा थियो, अहिले अब 253 भएको छ. Non-bailable offences there were 209, now there are only 195. Compoundable offences 41 थियो, अहिले 42 भएको छ. Compoundable offences with the permission of the court used to be 12, now there is 14. And total number of non-compoundable offences earlier used to be 430, now there are 408. So next is the offences trial by sessions court. पहिला चाहिँ 160, now it has been increased. We can see that the number of offences triable by magistrate has also decreased. So कतिवटालाई चाहिँ increased punishment because increased भएको छ, त्यसले गर्दाखेरि चाहिँ the offences are not triable by the sessions court. And the number of offences triable by magistrate of first class earlier used to be 172, now it is 145. Offences punishable with imprisonment for a term less than 7 years or which may extend to 7 years earlier used to be 255, now it is 237. Total number of offences punishable with imprisonment for a term of 7 years or more earlier was 180, now 177. Offences punishable with imprisonment for a term of 10 years or more earlier it was 110, now it is 107. And offences punishable with imprisonment for life or death penalty is 71, which used to be 71, now it is 78. So these are the changes now in BNS compared to IPC. पहिला चाहिँ अहिले नयाँ BNS मा we have 18 new sections which have been included, including the repeal and saving section. 20 sections have been deleted. Okay, in 36 offences, punishment of imprisonment has been increased. 84 offences ma चाहिँ punishment of fine have been increased or defined or added, and 23 offences ma mandatory minimum punishment has been given in terms of imprisonment, and 6 offences the punishment of community service has been introduced. So यसमा चाहिँ what we can say is earlier there used to be only 2 categories in gender, one was female and one was male. Now a third category has been introduced as transgender under section 2 subclause 10 of BNSA. पहिला चाहिँ अन्त when this imprisonment for life भन्ने पनि it went on a lot of changes. पहिला it used to be considered as imprisonment for the entire period of a person's life, eh? Then it became 14 years. Now under BNS what has been mentioned is punishment of imprisonment for life has been specified as imprisonment for 20 years under section 6 of BNS, unless there is a specific mention remainder of a person's natural life भनेर. त्यो specific mention गरेको छैन त्यो imprisonment for life भनेर त्यसको भनेको छ भने चाहिँ it will be 20 years, otherwise specifically mention गरेको छ भने चाहिँ it will be for the remainder of a person's life. And another change which has come is पहिला चाहिँ with regard to criminal force with intent to disrobe a woman भन्थे नि, पहिला चाहिँ a woman was specifically used, but now in के भन्छ woman was used by any man or person. पहिला चाहिँ खालि a man who was disrobing a woman with intent to outrage her modesty, पहिला एउटा म्यानलाई मात्रै भनेको थियो, but then now even the entire genders, even a woman or even a transgender will be liable for committing a punishment of the intention to disturb a woman भनेर आएको छ है. तर यसमा what we can see is still that we are lacking, even in the BNS we are lacking any offense which is committed against a transgender or a man भनेर चाहिँ त्यसलाई चाहिँ include गरेको छैन. So it is still against a woman, but only by a person भनेको छ instead of a man. अन्त त्यसरी नै 366A मा चाहिँ पहिला चाहिँ procuration of a minor girl भनेको थिए, but now it has been changed to child. Child is a person, any person under the age of 18 years, right? So protection has been provided to all the children irrespective of their gender. Suffering days, पहिला grievous hurt मा it used to be 20 days. No, a person who's not who's incapable of doing their day-to-day life activities, right? 20 days सम्म चाहिँ भन्थ्यो. Now it has been reduced to 15 days. अन्त voluntarily causing grievous hurt by use of acid मा चाहिँ पहिला चाहिँ खालि injury and hurt मात्रै भनेको थियो. Now it has included causes a person to be in a permanent vegetative state भनेर भनेको छ है. So we can see that the community service has also been introduced, but then I would not say that it has been introduced for the first time, because पहिला नै community service भन्ने चाहिँ यो Juvenile Justice Care and Protection Act मा पनि it was already there. Section 18 ले चाहिँ भन्थ्यो, and order the child to perform community service under the supervision of an organization or institution or a specified person or persons identified by the board. त्यसले गर्दाखेरि चाहिँ अलिकति डिपार्चर भएको छ प्युरिटिभ सिस्टममा, but then it is not exactly a new concept. Sorry, I forgot to change the slide, is it? So these are the sections which have been excluded under the BNS. So servant of government, including अघि भन्नुभएको थियो सरले ब्रिटिश इन्डिया पनि भन्नुभएको थियो, justice of peace, queen, British calendar सबै exclude गरेको छ यसमा है. And under section 2 subclause 20 मा BNS को चाहिँ अब under BNS चाहिँ year and month चाहिँ now has to be reckoned as a Gregorian calendar instead of British calendar. पहिला चाहिँ चल्थ्यो है. So now that has also been changed, and India has been excluded section. Construction of reference to transportation, sedition has also been excluded. But sedition, although it was excluded, it was excluded earlier, but then अहिले नयाँ section आएको छ 152 of BNS, which has come in the form of a treason. So त्यसलाई एड गरेको छ. पहिला although seditionलाई चाहिँ निकालेको थियो, तर अलिकति चेन्जेस ल्याएको छ with regard to purposely or knowingly by words either spoken or written or by signs or by visible representation or by electronic communication भनेर add गरेछ or by use of financial mean or otherwise secession or armed rebellion or subversive activities or encourages feelings of separatist activities or endangers sovereignty or unity and integrity of India. So यसलाई चाहिँ add गरेछ पहिला सेडिसन निकालेकोमा चाहिँ ट्रिजनको हिसाबमा चाहिँ 152 of BNS भनेर चाहिँ नयाँ एउटा सेक्सन एड भएको छ है. अन्त 153A punishment for knowingly carrying arms in possession or organizing or holding or taking part in any mass drill has been taken out. Abetting in India the counterfeiting of coin out of India, import or export of counterfeit coin, import or export of counterfeits of Indian coin, fraudulent use of false instrument or weighing machine पनि भनेको छ. After that, fraudulent use of false weight or measure, being in possession of false weight or measure, making or selling for false weight or measure, and the attempt to commit suicide has also been excluded under the BNS. This is a progressive omission which views attempt to commit suicide as a mental health crisis as opposed to a crime, And the यसमा चाहिँ what has been added अलिकति modification गरेको which has been added is section 226 of BNS which says attempt to commit suicide to compel or restrain any public servant from discharging his lawful duty. So that has been अलिकति modified and added as a new section in BNS. Thug has been removed. Punishment for thug has been removed. Unnatural offences under section 377. Now it has under BNS it has gone even beyond the case law of Navdeep Singh Johar versus Union of India. जसमा चाहिँ खाली which had only decriminalized consensual sexual activities between the adults. But now under BNS what we can see is even the offences of adults like acts of bestiality or sodomy भन्ने त्यो कुरालाई चाहिँ BNS मा add गरेको छैन. So that has like altogether been repealed from BNS. So nothing is there. Unnatural offences भन्ने एउटा topic section नै छैन अब BNS मा है. Similarly, lurking, house trespass by night हरू पनि निकालिएको छ. But it has been modified to house trespass and house breaking after sunset and before sunrise भनेर section 331 of BNS मा add गरेको छ. Similarly, adultery has also been removed now. This has also adultery earlier was struck down by the Honorable Supreme Court of India, Joseph Shine versus Union of India, and it was thought that it is violative of Article 14, 15, 21 of the Constitution. What we can understand is that the law has chosen to leave the issue between a married couple. Let them decide for themselves and not criminalize a person for committing a marital offense because it does not fall under the category of an offense which is committed against the state as a whole but only against a particular individual. It has been also removed. So we can see that child has been added which says that it is a person below the age of 18 years which is used in place of a term which is minor, पहिला चाहिँ minor भनेर युज भएको थियो IPC मा. Now it is come under the title of child. And abetment outside India for offense in India committed in India पनि add भएको छ. Sexual intercourse by employing deceitful means. पहिला चाहिँ अब if anyone has sexual intercourse with a person by promising to marry her or something like that or give her any kind of a job or something, some kind of remuneration, त्यसमा चाहिँ अन्त त्यतिबेला चाहिँ if something happens like this, then this also comes under the sexual intercourse by employing deceitful means and it has been made as an offense. And the hiring, employing or engaging a child to commit an offense has been added as a new section. Punishment for murder has also been added. This section 1032. 1032, it specifically talks about when a group of 5 or more persons acting in concert commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief or any other similar ground. Each member of such group shall be punished with death or imprisonment for life and shall also be liable to fine. So this is something like mob lynching, right? यसलाई पनि एउटा नयाँ section offense बनाइदिएको छ BNS को under. Another one is causing death by negligence. यसमा चाहिँ even negligence by a medical practitioner has also been included, and the organized crime has also been included as a new section, and petty organized crime हालेको छ. Terrorist Act. Now the interesting thing is that Terrorist Act under the BNS exactly mirrors the Terrorist Act, which is mentioned in Unlawful Activities Prevention Act. Right? Therefore, it is unclear why this same set of sections has been included in BNS, because यसै हेर्नु पर्यो भने UAPA मा 18 to section 18 to 21 has it corresponds exactly to the clauses, the several clauses under section 113 of the BNS Act, right? And the यसमा चाहिँ in order to because of such overlapping, explanation clause पनि हालेको छ यसमा चाहिँ, which says that explanation to Terrorist Act मा चाहिँ के भनेको छ भन्दाखेरि चाहिँ that an officer not below the rank of SP shall decide whether to register the case under UAPA or BNS. So एउटा option दिएको छ, but then surprisingly this still contrary to the general rule that if an act falls within the definition of an offence under those two acts, then special provision or special acts of the special act ko hisabma will go ni na. So it kind of still makes the new provisions of Terrorist Act under BNS redundant also. And the Terrorist Act surprisingly it has been brought under the category of in the chapter of offences affecting life under human body, except instead of offences against the state, because Terrorist Act is something which is done against the state and not against the human life. We understand it. So that has been brought under the chapter of affecting human life. So that is also there. So all of these have also been added: voluntarily causing grievous hurt, acts endangering sovereignty, unity and integrity of India, assaulting or obstructing public servant when suppressing right. While there used to be one section 353 which was also obstructing or like manhandling a public servant, but then as much as specifically suppressing right. So when the person is engaged in any activity of suppressing right, the police officer, when a person tries to obstruct the person, public servant, then this act comes into play. And imputations, assertions prejudicial to national integration, attempt to commit suicide to compel or restrain exercise of lawful power. Snatching has also been brought under a different section as an offence under BNS. Theft go under, we could understand, but it was not clearly mentioned in the IPCA. And the mischief also has come, another section of mischief has also come. And making or possessing counterfeit seal with intent to commit forgery punishable under section 338. And repeals and savings. Repeals and savings, however, it, like Karna sir was also saying and Vinay was also saying, that it protects the previous operation of IPC or anything done or suffered under the IPC. So whatever has been done or any case which has been registered prior to 1st of July, which will still be which will still be done under the IPC till the case is like completely over. So that's the part. So we can go back to the other slide. Sentencing policy. Okay, so sentencing policy under the BNS. While under IPC there were 5 types of punishment provided. Section 53 one was death, another one was imprisonment for life, another one was imprisonment of 2 descriptions, as simple and rigorous. 4th one was forfeiture of property, and 5th one was fine. And the 6th one, which has been introduced, not exactly introduced, but then added in BNS, comes under 4F, which is community service, like we've already discussed it. So, community service for petty offences, which like public servant unlawfully engaging in trade, which comes under section 202, non-appearance in response to a proclamation, which is 209, attempt to commit suicide or compel or restrain exercise of lawful power of public servant, section 226, petty theft on return of theft money under section 303 part 2, misconduct in public by a drunken person, section 355, and defamation under section 356 2. So under BNS, if payment of fine को default भयो भने or community services जेमा लेखेको छ petty offences मा, if default is done in that cases, then the following punishments are given. पहिला IPC मा it used to be fine not exceeding 50, but then अहिले 5,000 or community service भनेको छ, त्यसमा चाहिँ 2 months छ. And earlier in IPC, where in place of 100 rupees, अहिले चाहिँ 10,000 को fine or community service छ र त्यसमा default भएको छ भने चाहिँ it has to go for 4 months. And in any other case, पहिला IPC मा चाहिँ 6 months हुन्छ, now चाहिँ imprisonment not exceeding 1 year will be given as a default fine. So these are the sections in which death has been given as a punishment. Death has been specified under BNSI. Rape on a woman under 12 years, rape and inflicting injury causing death or resulting in a persistent vegetative state of victim, gang rape of women under 18 years of age, section 71 repeat offenders, murder by 5 or more persons, this was mob lynching, murder by life convict, abetment of suicide of child or person with mental illness. In our Sapema death as a punishment has been added. And even these, attempt to murder by a person under sentence of imprisonment for life, organized crime, terrorist act, kidnapping for ransom, waging or attempting to wage war or abetting the waging of war against government of India, abetment of mutiny if mutiny is committed in consequence thereof, conviction and execution of innocent person in consequence of false evidence, and dacoity with murder. In our Mapani, now the death as a punishment has been provided. Actually, I had 2 other slides which this much ago I was supposed to show. Details of offences where punishment has been increased, mandatory minimum punishment where BNS may act गरेको, but then now I don't know. So these are just the details of offences where the punishment have been increased. They're like about there are about 36 such offences. So you can see if it is clear. Okay, so the red ones, are in IPC, which used to be earlier. The punishment this side is also, the red ones used to be in IPC. Green ones say add one, PNS Congress, and then it all shows the details of offences where the punishment has been increased now as opposed to what it used to be in IPC earlier. So this one, I think it is not necessary to go through because court mother it like staff but it is just a chart which shows it easily. There's another chart also, mandatory minimum punishments भनेर. So in all the cases पहिला चाहिँ minimum mandatory punishment in specify भएको थिएन. Now in these cases the minimum punishment has been provided of not less than 7 years, not less than 5 years, but which may extend to 10 years भनेर. So we can see now that imposition of fine as opposed to what used to be earlier in one IPC of 1860, now it has been like considerably increased. So in point number 6, serial number 6, Yeah, 111.5. This is a new section, right? Which is intentionally harboring or concealing any person who committed offense of organized crime. यसमा चाहिँ imprisonment of not less than 3 years, which may extend to imprisonment for life, everything. But then in this case, the exemption has been provided to the spouse of the offender, because privileged communication भनेर हो कि के हो, but then the spouse is exempted from any offense if he or she is found harboring or concealing the person which is committed offense of organized crime. So these were the main points which I thought I should mention in the program today, but then apart from that there is not much, because we still have to also go through the new sections and new acts which has been implemented. I think only the FIRs are coming, some FIRs are coming, but then we have not started acting according to this new laws also, so we'll also have to see how it goes. Anyways, what we can say is that by looking at all these, we can see that BNS has brought some positive changes in imposing more stringent punishments, but it kind of still continues to retain marital rape, not below 18 years, as an exception to rape, and has also failed to make any offense of rape against make the offense of rape gender neutral. Like I said, transgender lie or a man like any, if something of some offense like that of a rape or something has been committed, then unaru chai victim ho haina, that is still not decided in this BNS also, and solitary confinement still continues to stay in today's age also. Actually, अब यसै हेर्नु पर्यो भने human rights को हिसाबले त that should have been abolished, and with the introduction of this offense for act endangering the sovereignty, unity and integrity of India also, यो पनि अलिकति dangerous नै situation छ, because it is still ambiguous as to what may be considered as an offense which is endangering the sovereignty, because a person's right to freedom will be curtailed in a much higher level because of this existence of this offense, त्यसले गर्दाखेरि चाहिँ so we can only hope that this new acts will be helpful in curtailing the offenses and then bringing justice to the persons which the act has been implemented. So त्यसले गर्दाखेरि चाहिँ I think more than that, I don't have anything else to inform also. If there's anything that you want to ask, or if there's any clarification that you did not understand, I think this is it.